an Àlia podcast on AI regulation and tech M&A in Spain and Europe. If you have ever run an acquisition or sat on the sell side of one, you know this moment. A data room opens on Friday. There are 4,000 documents inside, signing in 3 weeks out. And someone wants a first read by Monday. For most of the history of deal making, the answer to the problem was people. A room full of lawyers, a lot of coffee, and a close-by-close read. That picture is changing, and it is changing faster in 2026 than in the 2 years before it. The word you keep hearing is agentic. Today, I want to take that word apart, show you what it actually does inside the transaction and a compliance file, and then walk through the part that matters the most if you build, fund, or run a company in Europe. The rules that now sit on top of all of it. I am Àlia, and this is the Àlia podcast. At Àlia, we advise startups, funds, scale-ups, and regulated businesses on exactly the things colliding in this episode. The AI Act, data protection, cybersecurity rules like NIS2 Andorra, crypto frameworks like MICA, venture financing, tech M&A, and the commercial contracts that hold it all together across Spain and the rest of Europe. So this is the view from where we sit, advising the companies living through this shift. I will keep it practical, no hype, no doom, just what is real, what is coming, and what a founder or an investor should be doing about it now. So, what agentic actually means? Let me start with the word, because it gets used loosely. For the last couple of years, most legal and business AI worked like a very capable assistant. You gave it a prompt, it gave you an answer. Summarize this contract, draft this clause, compare these two versions. Useful, but reactive. It waited for you. An agentic system is different in one specific way. Instead of answering a single question, it plans and carries out of a sequence of steps towards a goal. And it only stops for you where you want it to stop. The industry framing is multi-step task execution with human oversight built in. So instead of summarize this document, the instruction becomes review this entire data room against our checklist, flag the issues, sort them by risk, and draft a first cut of the issues list. The system decides the order of operations, works across many files, checks it down outputs, and hands you a structured result. The reason 2026 is the year people keep pointing to is adoption, not invention. By the start of 2024, only around 14% of law firms and legal teams had generative AI deployed across their organization. 2 years later, that figure is closer to 43%, and for large firms and corporate legal departments, it is approaching everyone. Generative AI is now ordinary. The frontier has moved to agents. And that frontier is earlier than headlines should suggest. Surveys this year put widespread agentic adoption at under 20% of organizations, with about half either planning it or waiting it. So we are at the experiment to implementation hinge, which is precisely where generative AI sat in 2024. If the pattern holds, the next 18 months are the build out. The major providers are already moved. Several of the big legal research platforms now run agentic workflows that plan and execute multi-step tasks. Others use multiple specialized agents that collaborate, one to orchestrate, others to research, search, and handle documents. The direction across all of them is the same. Less go to the AI in a separate window, more the AI shows up inside the tools you already use. I am naming the pattern rather than picking a winner because the right tool depends entirely on your situation, and that is a conversation worth having properly rather than from a podcast. So Agentic AI inside the deal. Let me put this where it bites, which for many of you is the deal itself. Due diligence is the natural first home for agentic AI in M&A for a structural reason. The work is high volume, time compressed, repetitive in form, and unforgiving of misses. A single overlooked charge of control clause in a vendor contract can stall a deal worth hundreds of millions. That is a perfect target for automation because the cost of doing it by hand is huge, and the cost of a miss is huge too. The agentic version looks like this. You point the system at the data room, it works across contract types at once, vendor agreements, employment terms, IP assignments, compliance records, litigation files, and applies your criteria to every document. It does not just summarize each file, it identifies missing clauses, non-standard terms, one-sided liability caps, absent data, protection language, and returns one structured table organized by risk. You filter by clause type, sort by severity, and compare terms across counterparties without opening 40 separate documents. The more advanced framing, where agentic earns the name, is the digital associate that goes past flagging. It cross-references findings in the data room against the term sheet and against precedent. It notices where a draft agreement drifts from what was agreed, and it proposes language, drafting a first cut fixed clause that human reviews and decides on. Notice what that does to the shape of the work. The extraction, the first pass markup, the issues list assembly, those move towards the machine. What stays firmly human is judgment. Which risks actually matter for this buyer? How hard to push on an indemnity? What the strategy is? The promise is not to replace the lawyer, it is give the deal team back the hours they spent on the writ. So they spend them on the negotiation. Deals that used to take months of review are being described as compressing into weeks. I want to be honest about the limits because this is where careful operators separate from the crowd to risk trouble with these systems. First, mistakes scale. A bad summary wastes an afternoon. A bad autonomous workflow can embed the wrong claim across 10 documents, or send the wrong thing to the wrong person before anyone notices. The blast radius is larger precisely because the system acts across many steps. Second, the hallucinated citations problem, which is no longer theoretical. Fabricated cases and sources have appeared in hundreds of court filings worldwide, with several hundred documents, incidents recorded by early 2026. Courts have noticed and are reacting. The lesson transfers cleanly to deals and compliance. Every output gets a source you can click through to, and nothing autonomous leaves the building without a human gate. So, when you evaluate a tool, the features that matter are not the flashy ones, a visible record of the steps that the systems took. Human approval points with a clear stop button. Memory that stays scoped to the matter and does not leak across deals or clients. A clickable source behind finding those 4 things are what make agentic output something you can stand behind. And they are the first thing we look at when a client asks us to bless a tool before they put confidential data into it. The regulatory layer, the EU AI Act. Now, the part that makes this a European story and not just a Silicon Valley one. The EU AI Act. Here is the clean version of where things stand, because the timeline has moved a lot of older summaries are now wrong. The Act entered into force in August 2024 and rolls out in phases. the prohibitions of unacceptable risk practices and the AI literacy obligations have applied since February 2025. The governance framework and the rules for general purpose AI models came during August 2025. And the date everyone circled, the 2nd of August 2026, is when the enforcement machinery, the transparency obligations, and the innovation support measures switch on. But there is a significant update anyone advising on this needs to get right. In November 2025, the Commission proposed a package called the Digital Omnibus on AI, and in May 2026, the EU institutions reached a provisional political agreement on it. The headline effects is that the heaviest obligations, the ones for high-risk AI systems, are being deferred. Use-based high-risk systems, the Annex 3 category, moved from August 2026 to December 2027. High-risk AI embedded in already regulated products. The Annex 1 category moves to August 2028. There is also a shorter slip on certain transparency-making rules into December 2026. The crucial caveat. These deferrals only take legal effect once the omnibus is formally adopted and published in the official journal, which was expected before that August 2026 date. So the honest position right now is that August 2026 is a leave date for the parts that were not deferred. And the high-risk relief is provisionally agreed but pending formal adoption. You plan for both and you watch the official journal. Why does this matter to a founder rather than only a compliance specialist? We have two reasons. First reason, the penalties are real. Using a prohibited practice can reach 35 million euros or 7% of worldwide annual turnover. High-risk non-compliance can reach 15 million euros or 3%. The Act has extraterritorial reach, so it bites any system that touches people in the EU, regardless of where you are based. The second reason deserves its own segment because it is the one most likely to surprise you on your next raise or exit. So, Spain, and why the local picture is unusual. Spain, specifically because the national picture here is ahead of most Europe and it shapes how we advise. Spain created AESIA, the Agencia Española de Supervisión de la Inteligencia Artificial. As its national authority, it was one of the first dedicated AI supervisors in Europe. And it has not only been idle. AESIA has published a large set of practical compliance guides, more than 20 by some counts, and ran a regulatory sandbox with real projects testing systems under supervision. Privacy professionals have called this some of the most concrete official interpretation of AI Act obligations available anywhere in the Union, to the point where regulators in other member states use the Spanish material as reference. The posture so far reads as guidance first, enforcement second. That is genuinely helpful for a company trying to get it right. But I would not let anyone misread it as lenient. Spain's Data Protection Authority has been among the most active enforcers in Europe by volume of fines. The institutional culture around enforcement is assertive, and the formal investigatory and sanctioning powers are already in place. There is also a national law layer arriving on top of the European one. In May 2026, the Spain Council of Ministers approved a draft organic law on the proper use and governance of AI, aligning the national framework with the EU regulation and setting out of the domestic governance and penalty machinery. And supervision is not AESIA alone. For a fintech or capital markets business, expect the sectoral regulators to play a role too. The securities regulator, the Bank of Spain, the Data Protection Authority, ISC coordinates, but oversight is distributed by use case. For your company, the regulator you care about depends on what you actually do, which is exactly the kind of mapping we do at the start of an engagement. The part that hits your raise and your exit. Here is the angle. I could build a strategy around, and it ties together everything Àlia works on. We have been talking about AI as a tool you use, but in 2026, AI is increasingly a thing that gets done to you in diligence. Picture the buyer seat on the lead investors. You are acquiring or funding a company. That company builds an AI product or it deploys AI inside hiring, credits, or customer operations. Every one of those facts is now a diligence work stream. Is the company a provider or a deployer under the AI Act? Will any system be classified as high risk? Has it done the conformity work, the technical documentation, the risk management? It is registered where it needs to be? If it handles personal data, is the GDPR position clean? If it is in finance or critical services, where does it sit on DORA or NIS2? If there is a token or a crypto element, is MiCA in scope and is licensing handled? This reshapes the documents. AI Act and data compliance become representations in the purchase agreement or the financing docs. They become categories in the disclosure schedules. They become specific indemnities because the market is already moving toward clauses that allocate AI risk between the parties. Partly because the law has not settled who is liable when an autonomous agent gets something wrong, the user, the developer, or both. That opens question, is a gift to whoever drafts the risk allocation well and a trap for whoever ignores it. So, the same agentic tools that help you read a data room faster are also creating a brand new category of what is inside the data room. Your AI and data posture is now an asset or a liability that gets priced. The companies that treat it as something to clean up the week before a raise tend to lose value or time. The ones that treat it as part of how they build, with the contracts, the data governance, and the AI Act mapping is in place early, walk into diligence with an advantage. That preparation is a large part of what we do, and the window created by the deferred high-risk deadlines is exactly the time to do it calmly rather than under deal pressure. So, the honest skeptic's case. Let me close the loop with the counter-argument, because a one-sided story helps no one making real decisions. Not everyone is bullish. Some respected analysts think that AI hype cycle is cresting and a correction is coming. There are projections that a meaningful share of planned AI spend will slip into later years over return concerns, and a forecast that a large fraction of agentic projects will be cancelled by the end of 2027 on cost or unclear value. Those are real signals. I read them not as do not bother, but as be disciplined. The teams that win with the treat AI as infrastructure, a governance policy, training, independent measurement, or whether it actually saves time and money. A clear story on data regulation and confidentiality that can tell a customer, an auditor, or an acquirer. The team that treats it as magic shortcut are the ones who end up in the cancelled project statistic or in a privacy or accuracy problem that surface at the worst possible moment. So here is where I will leave it. The agentic shift is genuine, and in M&A it lands first and hardest, in due diligence where the economics are overwhelming. The European rules are real. The headline 2026 date is partly deferred, but not gone. And Spain is and usually well equipped on the supervisory side. And the sharpest move, whether you are building, funding, or buying, is to hold those two ideas at once. Use the agents to move faster and get your own AI data and contract posture in order, because that is what shows up in every cross-border deal that touches this market. That is the episode. If you are waiting on an AI tool, preparing for a rise or an exit, or trying to work out which of these European rules actually apply to your company, that mapping is the kind of thing we do at Àlia every week for founders, funds, scale-ups across Spain and Europe. If it could help to talk it through, you can find us at aliagroup.ai, and there is no charge for a first conversation to figure out what you actually need. Thanks for listening. The regulatory picture is moving month to month, so I will keep coming back to it as the omnibus is formally adopted and as more guidance lands. Until next time.